Good morning. Can you see the end? If you want me to stand up here and drop my britches, I will. But yes, you can see the end. Of my Senate members, are any of y'all chairman? Everybody's a chairman in the Senate. Y'all, I'm going to give you the same crap my people have been living with here in the last. Y'all passed any House bills out? So, to pass out or out pass? It's about time you did something. Okay. Because I hear I don't pass any Senate bills, and I've been putting every one that comes down through here except for two, and they'll die here with me. Isn't that right, Mr. Harper?
I hope not one of them, Mr. Chairman.
Y'all bow with me, please. Gracious Heavenly Father, here we are. I know we're sinners, and I know that you watch us. I know you forgive us. We ask for your grace and your love, even though we probably don't deserve any of it. Let us do things that please you. Lead us and guide us. Keep us in your arms. I ask this in my Savior's name. Amen. I'm going to take care of one bit of business here. I need a move to recommit Senate Bill 99 back to non-civil, junior non-civil. Any opposition to that? And I want to recommit Senate Bill 160 to House non-civil. Any opposition? Motion carries. What are you doing here? I thought we did all the governor stuff.
So we've got a couple of them. My senator was afraid to come, so.
He should be. You're up, Mr. Coomer.
Thank you, Mr. Chairman. I'm asking for two measures, both under modified structure. The first one is on page 1, Senate Bill 133, the Opportunity School District Establishment Bill, and Senate Resolution 287 on the second page, which is the constitutional amendment. The amendment and the bill is the implementing legislation for the amendment.
Any question? We've heard a pretty. Are there any questions, Mr. Coomer? We've had a pretty good explanation of those by the governor himself, so no questions, Mr. Coomer. Thank you.
Thank you, Mr. Chairman.
Mr. Broderick.
Thank you, Mr. Chairman. I'm here this morning to ask for H.R. 640, which is the second on the top of the first page. It's listed as a joint study committee, but it was passed out in a substitute as a House study committee to look at the feasibility of improving school-based health clinics throughout the state. There are a number of those in the state that are very successful at not only dealing with the acute health care of kids, and let's see if we can keep them in school and keep them healthy, and also looking at some mental health issues as far as children go. And I think there'd be some benefit at looking at the structure of these so that we could give guidance to other school systems throughout the state to perhaps get the benefits of a school-based health clinic. Appreciate your favorable consideration. Thank you, Mr.
Any
Chairman.
questions of Mr. Broderick? No questions, good. Thank you.
Thank you.
Mr. Jeffries.
Thank you, Mr. Chairman, committee members. Under modified open rule, down second from the bottom, Senate Bill 119, Water Professionals Appreciation Day. Ask for your favorable consideration.
No questions, thank you.
Thank you, Mr. Chairman.
Mr. Stone.
Good morning, Mr. Chairman, members of the committee. To ask for a favorable consideration of SB 134. This is the anti-speed trap bill that's been perfected in the House Judiciary Non-Civil Committee. I'll be happy to answer any questions.
You got a couple, hold on. Mr. Roberts.
Thank you, Mr. Chairman. Can you run over real quick the differences in what you passed out of the Senate and what the House changed in committee?
What we passed out of the Senate removed the exception for any tickets that are written for 17 miles per hour and above.
40%, the 40% part?
Yeah, and it was a 40%. That was not changed in the Senate. In the House, it was reduced to 35%, and the 20 and over, as far as speeding tickets, are still accepted. That's the super speeder tickets.
Thank you.
Mr. Fleming. He's waived. No other questions. Thank you.
Thank you very much.
Mr. Dugan.
Thank you, Mr. Chair. If you look under modified structure, the fourth from the bottom, looking at Senate Bill 131, it's a department bill that offered to carry through the Senate for the DBHDD, streamlines efficiencies within the crisis stabilization units, 26 of them across the state.
No questions. Thank you.
Thank you, Mr. Chairman.
Mr. Harper.
Good morning, Mr. Chairman, and contrary to belief that you got rid of me yesterday, I'm back, and I apologize, but it's great to be back with you. Under modified structure rule, third down, the Senate Bill 100 is Department of Public Safety bill. It updates MCCD code, and also it has provisions in it that get rid of license expenditures if it's not vehicle or driving related. So it's just I think it's a good cleanup bill for our code, Mr. Chairman.
Hold on. Mr. Fleming.
Thank you, Mr. Chairman. Senator, what situations are no longer going to be where licenses are suspended that are under current law?
Under the bill, there are a multitude of violations that you can get your license suspended for if you're not actually operating a motor vehicle. All of those are being removed except for two. One of which is agreement reached with the governor's office and the Department of Human Services in regards to child support. We put some provisions in there that strengthen the ability for an individual to be informed of ways that they can get their license back to continue to drive even though they're deficient in their child support payment. The other thing is the parental right that you have as a parent under current code to request the suspension of your license or your child's license if they're under 18 years of age. There was some pushbacks from some of my colleagues in the Senate. We worked together. We put that provision back in there. But every other provision, such as get drug convictions, etc., under current code, you can have your license suspended on a drug conviction that has nothing to do with a motor vehicle. So a lot of those provisions are being removed, and we're taking them out. So
in the current law, you get arrested for drugs, you can have your license suspended, and
yes.
We're going to say that that's not going to be the case anymore.
That will not be the case anymore. And we have Chairman Rice has it. We have a list from the departments of, this is supported by DPS and DDS, obviously, that we can show you how many license suspenditures have actually taken place based off of these certain convictions, if you would like to see that.
Well, are we talking about 1,000 people
No,
that are
we're-
going to be able to drive that couldn't because they were doing drugs and selling drugs?
We're not talking as that very many people at all, actually. It's actually a small number. And the thing is, the thing that the Department of Public Safety, their job is to protect the highways and byways in regards to people that are actually driving. They're spending time suspending and taking care of ALS hearings, et cetera, on people's driver's license that has nothing to do with them being in a motor vehicle. So we're making sure that they continue to stay in their lane, so to speak.
Thank you. Thank you.
Yes, sir.
Mr. Willard.
Yes. Good morning, Senator.
Good morning, Mr. Chairman.
We had a bill that we passed through the House that has some language dealing with the requirements of what I call due diligence notice when there is going to be a suspension of a license. Currently, that has to be done as a certified letter from the state. We're now putting that back to the local courts as a means of making notice. Is there anything in your bill that changes?
In this legislation?
Yes, sir.
No, sir.
Okay. Thank you.
Mr. Leader.
Thank you, Mr. Chairman. I just want to make sure I understand your answer to a question Representative Fleming asked you. When you said license suspension about drugs, you're not talking about if you get your license suspended while you're operating.
No.
If you're
operating a vehicle and you are in possession of drugs, you can still have your license suspended under current law. This does not take that ability away. No. The only time if an individual was in their home and they got caught with drugs, this is just one example. There are a multitude of other examples I could give, but I just used that one as an example. They can have their license suspended sitting in their rocking chair at their house if they got caught with drugs and charged for that offense.
Chase, there's no safety issue for other citizens that are in their motor vehicles.
No,
that's what I want to make sure. The bill
correct.
does not do that, right?
No.
Thank you.
Mr. Rice.
Thank you, Mr. Chairman. Is it not true, Chairman, that the violations we're talking about, the non-driving violations, by record violations, there's 0 for all the ones you're taking out? There haven't been any violations.
That is my understanding of the sheet that you and I both have reviewed.
No more questions. Thanks.
Thank you, Mr. Chairman. I appreciate it and appreciate y'all's due diligence. Thank you very much.
Mr. Huffstetler. And before he speaks, he's my senator, so y'all can abuse him all you want to.
Thank you for that warm introduction, Chairman Meadows. I've got Senate Bill 114. The community service boards had been brought out from under Department of Public Health, and the protocol agreement had not been changed. So it's a cleanup to that. It passed unanimously out of the House. Chairman Cooper, as you see, is carrying it. And I'll further add that my retirement committee has passed out every single House bill that's come over, and we're done for the year.
Huh. Okay. Okay, it looks like we got 20 questions. No questions, thanks.
Thank you. Thank you very much, Mr. Chairman.
Ms. Orrock.
Thank you, Mr. Chairman. Committee members, I'm here today to request Senate Bill 109, which is under modified structure rule, and this is came out of the Senate unanimously, came out of the Health Committee in the House unanimously, and it clarifies the language that we've had since 2010. We have had a form that the Department of Public Health does called a physician's order, and it takes your advance directive wishes and puts them in a form of a medical order with the physician and the patient or their designee as the signers.
Mr. Fleming.
Thank you, Senator. My question is, what is the current law, and what are we changing it to?
Thank you. In 2010, we authorized the Department of Public Health to create the form, the physician's order, and it is up online, and it has been in place since 2010, and it conforms to about 90% of the POLST forms around the country. What the bill does is clarify when the POLST is used, and when it got to the Health Committee on the House side, it was asked by the nursing homes and the Alzheimer's to include provision that a family, a patient can that's battling with a dementia diagnosis, an Alzheimer's diagnosis, brain function diagnosis, that they can trigger that pulse, that is, fill it out with their physician much earlier. Because they'll not be able to do that in the latter stages of their disease. That was a change that was made on the House side. The hospitals and the nursing homes wanted to clarify the immunities as they use the pulse and which reflects the wishes of the patient. That they wanted language in to clarify liability and immunity, and there is extensive language to that effect in the bill.
My question goes to, I thought you said something about giving permission to an individual to make decisions for someone who's incapacitated. And my understanding of current law is that my wife can do that, my family member can do that. But if I'm not conscious, somebody outside of that small group, a person that's not married to me or related to me, cannot without a court order. Are we changing that?
My understanding is that when a person is in the hospital in the care of a physician and unable to speak for themselves, the primary task of that, in addition to keeping them alive and treating them, is to locate the individual that can speak for them. If they've done an advance directive and they have a designated agent, then that's who would be working with the hospital or the nursing home with the physician. If they haven't executed any sorts of paperwork, the hospital's got to determine who is the agent.
So we're giving the hospital now the power to say somebody other than a family member can make decisions?
I'm sorry, that's not, that doesn't, current law, that's not changed. This bill does not change that.
Okay, thank you.
Thank you for your question.
Mr. Rogers.
Thank you, Mr. Chairman. Senator, I did hear this in committee. I think the issue here is most people don't understand what an advanced care directive is, and this form is in addition to, and a physician has to fill it out and sign it. Is that not correct?
That is correct.
Okay.
That is correct. And it's to take that advance directive, ideally that the family and the patient already have, and put it in medical orders that then travel with the patient. If they have to be switched to another facility, if they go to the nursing home, if they go, if they move, if their care moves between different providers and different institutions, that is codified. The POLST moves with them, and its goal is for it to be the recognizable document that all medical personnel interfacing with that patient follow.
Mr. Chairman, may I follow up with another question?
I'm sure you can.
Okay. Thank you, sir. This is really dealing with patients that are terminally ill that only may have up to 365 days to live, correct?
That's exactly right. That was put in the law. That was put in this language, that 365. Senator Judson Hill crafted that language on the Senate side with me.
Okay.
And we did put in language in the House Committee sub that addresses the fact that if someone diagnosed with early dementia, early Alzheimer's, where they're going to lose brain function, that they go ahead and execute that with their physician at an earlier time.
Okay. Thank you, Mr. Chairman.
Mr. Setzler.
Mr. Chairman, to the lady, what level of legislative oversight is there going to be to the PULSE form itself? As this process moved over the years, the life and death decisions were being made pursuant to the check boxes on the form and what's selected, what's not selected. What level of comfort do we have as legislators? I mean, is the Health Committee going to be able to review this before a change is made to the PULSE form? what specific comfort level do we have as legislators that we're going to have some oversight of that process? Because what's on the form really is all determinative of life and death decisions for individuals.
And there's a national movement by medical providers to have the form be consistent and substantially similar in state after state. We put language in our bill that we don't accept a pulse from another state that's not substantially similar to ours and signed by the appropriate people. And we charge the Department of Public Health with maintaining that form, updating it as needed, and being answerable to us in that regard. Thank you.
Ms. Cooper.
Thank you, Mr. Chairman. In response to Representative Setzler, that pulse form has been developed, the one that's in use now, and it has been out there for a couple of years, 4 years.
We told them to do it in 2010, and by 2012 it was up and running. Mm-hmm.
Right. And the reason the need for this law is the hospitals wanted a great deal clarified, and we have done, and that has been done in this bill, so that the law will be more effective. And for the committee, when you do an advance directive, it's your wishes. And so when you do a pulse, it's sort of when the rubber has hit the road, and you and your doctor, the doctor has advised you that you are within your last 365 days. And one of the major differences is when you do an advance directive, it's basically your wishes. You can do it. You can sign it. There's no discussion with the physician. The pulse is done in consultation with the physician and signed by the physician and the patient at that period in life. Thank you.
Ms. Renner.
Thank you, Mr. Chairman. Senator, can you talk about the review provision in there, the individual review provision that you added, so that there was a discussion about the advance directive and the pulse could change over time, and you wanted to ensure that it was reviewed. Could you speak to that?
Well, the entire point of, in fact, there was a recent national article in the press around why advance directives don't work. And the point being, if they do not move into the medical system where you're getting care, it remains a dead document that's stuck in the Bible or stuck in the grandson's file drawer or a lawyer somewhere. It's to make the advance directive wishes. The whole point of this is to ensure that patients' wishes about their medical care are honored, not ignored and brushed aside.
Mr. Setzler.
I'm sorry, Mr. Chairman. I did have a follow-up question for the lady. I appreciate the indulgence. There's been grave concern nationally that pulse forms or mechanisms, as they are in 3 states, where someone can sign their rights or can sign an order authorizing physician-assisted suicide. Understand there was some effort that was not addressed in Senate committee, but on the floor there was a floor amendment added to prohibit this from being a mechanism for assisted suicide. Is that the case?
Thank you for that question, because we did address that language in the Senate. We put in specific language which says that nothing in this Pulse statute would in any way interfere or countermand or overrule the language that we have in law that forbids assisted suicide. So it goes right back to that code section that has been carefully crafted by this legislature on suicide.
And I'd simply raise that question because that was added on the floor in the Senate, not in the Senate committee, and pulse forms are nationally of concern with respect to that issue. I just would caution members it has been fixed in this bill, but it's something that I would encourage us all to maintain our vigilance over. Thank you.
Yeah, that was in an abundance of caution for people to be sure that they were not signing on to something that was overriding our state policy on suicide. Thank you for that question.
No more questions. Thank you.
Thank you so much. Appreciate it.
Thank you, Mr. Chairman, members of the committee.
Who are you?
I am Senator Michael Williams from Forsyth County.
You're new.
I am new, yes, sir. Freshman senator.
Your name's down here 3 times.
Yes, sir. Been busy at work.
We don't allow freshmen to have a bill until their 4th year.
May I ask for an exception?
Boy, I don't understand.
Yeah,
Did you? There you go. You got another mark against you. Mr. Williams.
Yes, sir.
Go ahead.
Thank you, Mr. Chairman, members of the committee. There are 3 bills, but one of those has actually been sent back to committee to be perfected by the House. The first bill is underneath modified open rule. It's SB 95, and this allows real estate brokers to place money they have in trust or escrow in an account at a financial institution, as long as that account is federally insured. And then the second one is underneath modified structure rule, which is SB 195, which allows the bonding industry to increase their fees for continuing education. It also requires a bench warrant to be issued if an individual does not show up for court.
While you're up there,
Yes,
go
sir.
ahead and speak to 160.
Sure. SB 160, basically what this does, it changes the order in which law enforcement shall enforce underage drinking. It makes it so that if a law enforcement approaches someone or sees someone under the age of 21 drinking, that they are to automatically issue a citation, then assess a situation, and if needed, arrest upon that.
Mr. Al Williams.
Thank you, Mr. Chairman.
Yes, sir.
Gentleman with the senator with the fine last name. Just a question on SB 195.
Yes, sir.
How much are we talking about increasing these fees?
It's at $250. It originally was $125. It was set back in 2002. It hasn't been increased since then.
Senator, I know you all talked about this in committee, but that's quite a catch-up at one time.
Yes, sir.
For bonds that are already pretty hefty.
I'm sorry, can you repeat that?
Bonds are already kind of hefty. That's quite a catch-up.
This is just for the continuing education for the bondsman.
But still a fee.
Yes, sir.
All right, sir. Thank you, sir.
Okay.
Ms. Abrams.
Thank you, Mr. Chairman. Senator Williams, regarding SB 160, was there any conversation with the Board of Regents about the implications of issuing citations and automatic arrest near college campuses, given the implications that could have for retaining financial aid? I mean, this seems to be a fairly aggressive approach.
Well, it's not an automatic arrest. It's the officer at his discretion shall arrest after the issuance of the citation. And no, I have not spoken with the Board of Regents, but I have spoken with the Chief of Police in Athens, and he is in support of this bill.
Has there been any conversation with any of the other colleges and their?
No, ma'am.
Thank you.
Mr. Gowitt.
Thank you, Mr. Chairman. I appreciate the minority leader's question. We actually were, I wouldn't say looking for that commentary in the committee, but we're aware to look out for it, and no, there was no objection from our folks in the higher education arena. No objection at all, frankly, in the committee, and we vetted out pretty well. We're actually taking it back this afternoon for a technical change that we thought should occur in the committee, and then it'll be on the 1 o'clock agenda if there's a further concern, but there was no expression of discomfort on the part of those parties.
Thank you.
Sure.
Thank you.
Okay, thank you.
Ms. Cooper.
Thank you, Chairman. I would like to put my name by Senate Bill 114 and ask that it be moved to modified structure. That's Senate Bill 114.
Wait a second. Go ahead.
Okay. I'd like to put my name by Senate Bill 114 and ask it that it be moved to modified structure. And I would like to ask for House Resolution 612. This problem was brought to me by a group of young African American women who are having trouble becoming pregnant, and brought to my attention what a problem this was. It does affect African American women more than Caucasians, but it is becoming a significant problem, and they would like to look at that and study it over and see if there's, anything that can be done to help them. Thank you.
Ms. Dempsey.
Yes, I'd like to ask for House Resolution 641. It became a substitute. It is not a joint. It is a House Study Committee on Children's Mental Health to look at the challenges and the changes that certainly are there on the early intervention front of dealing with problems at the beginning that are always expensive but become life-altering and very expensive to our state later.
Ms. Smith.
Thank you, Mr. Chairman and members of the committee. I wanted to notify the committee that I did receive notice today. I do not see Representative Earhart, but he has removed his hold on the Senate Bill 119, which is under modified open. I have an extensive document showing all the support, and that it's a water awareness day that most of our cities and counties participate in as well.
Mr. Hamilton.
Thank you, Mr. Chairman. I'd like to, Senator Gooch was in the room. He had to leave he told me to put together whip reports so they could get those House bills out today. But under modified structure, Senate Bill 4, and I also have a technical amendment on your desk that was the result of a Scribner's error, and I did confirm with the Ledge Council that the amendment was drafted correctly and passed correctly, but unfortunately when they put it into a committee sub, they put the new language in but forgot to, or it failed to delete the old language, and that's all this amendment does, is delete that those 3 lines that were inadvertently left in there. I'd also like to put the name beside Senate Bill 95.
Question from the chair. SB 4. Who ends up paying for those changes in utilities?
The organization that requests those changes, which would be the local government, which ultimately goes to taxpayers. But this is in a situation where the utilities are already there, and this is also very confined to a very small area in the city of Atlanta. But the government would, if they request them to make those relocations, then they would pay for those changes.
So the government would be making the request.
That's right, Mr. Chairman. This is not to benefit the utilities that we're talking about. It's the government has requested to the government to relocate those utilities, and so the utilities are simply asking to be recoup those costs that they're being told to do. That's what the amendment was. This right here, simply the amendment passed in full committee as well as the bill passed in full committee. This amendment on your desk is the technical amendment, simply striking the language that was inadvertently left in the building by Legislative Council.
Okay. Mr. Stevens.
Thank you, Chairman. The Senate Resolution 26, Senator Ligon was here yesterday asking for that. This is a real natural resource bill to connect the coastal Georgia Greenway to the East Coast Greenway, which runs from Maine to Key West, Florida, and Georgia is way behind on that.
Okay. Would you like to go ahead and speak to Amendment AM 400138?
Yes, sir. After months of discussion on a buffer down in our area, this, of course, today, as a result of EPD's decision that the letter that they have is not sufficient to create a buffer on coastal Georgia. We have a bill, Senate Bill 101, that does that, and the amendment before you is where most of the heartburn was at, and the bill gave a blanket exemption to a federal 404 permit. This just says that if you get a federal 404 water permit, that you have to have criteria in place for that exemption, and I ask for the committee to approve it.
And so do I. You have the amendment. You heard Mr. Stevens. I'm assuming that he will move on that. I do. He moves. Got a second. Is there any disagreement? Hearing none, that will be a rules amendment and will be on the desk tomorrow. Mr. Dixon? Mr. Rice?
Thank you, Mr. Chairman. I'd like to ask for Senate Bill 100 and the substitute that's on the desk, which is LC 39-1057S, which corrects a Scribner's error. 2 quotation marks were left out of the substitute, and this corrects it.
Okay, you've got it on your desk. It's LC 39-1057S. It would be a rules substitute for SB 100, and again, 2 quotation marks causes that many trees to die. You move, Mr. Rice?
Move on that.
Have moved. Any discussion? Any opposed? Okay. The SB 100 by rule substitutes passed. Also on your desk you have AM 390121, and that is a Mr. Hamilton's substitute. Mr. Hamilton.
Thank you, Mr. Chairman. That's what I spoke of earlier. This is simply correcting a Scribner error that was between what passed in the committee and when Legislative Council drafted it. They simply left in the lines that were supposed to be deleted. That's all this does. Has no material impact whatsoever on the amendment or the bill. Just simply corrects that Scribner error.
And do you move on that?
And I move, please.
Any opposition? All right, it's on.
Wait a second. We spoke yesterday. This is a technical amendment, so I'm assuming that this will be adapted as a rule substitute.
Nope, it's just going to be a rules amendment.
Okay, thank you.
All right. Listen up. For today's supplemental calendar, under modified structure, SB 133. Any opposition? It's on. Also for today's supplemental calendar, SR 287. Any opposition? It's on.
Thank you, Mr. Chairman. I'd like to move that we limit debate on both SB 133 and HR 287 to no more than 90 minutes, SR, I'm sorry, 287, to no more than 90 minutes each, inclusive of the opening 20 and closing 20.
We have a move to limit debate. We have objection. All those in favor of limiting debate, raise your hand. Those opposed? Okay. But debate is limited by what Mr. Golick announced. All right, then setting the calendar for Thursday. Under modified open, HR 640. Any opposition? Modified open, HR 641. Any opposition? Modified open, SB 119. Any opposition? So, modified open, SR 26. Any opposition? So, under modified structure, you've got SB 100 as a rule substitute. Any opposition? It's under modified structure, SB 101 with an amendment. It's under modified structure, SB 194. We can put it on tomorrow. SB 194, we have a move. Any opposition? It's on. Y'all think we ought to give that Williams boy something? It under modified structure, SB 195.
Move.
Any opposition? Bye.